Hi, my name is Mason Waring. I'm a CCK attorney, and I'm joined here with my colleague, CCK attorney Leah Small. Today, we're going to talk about what happens and what you could expect if your long-term disability claim needs to be filed in court. We're going to talk about why LTD claims may need to be filed in court, what some of the possible outcomes are, and what the associated costs may be with that. So let's get started. There are three phases, generally, that's how we block them, in a long-term disability claim. You have the initial claim, you have the administrative appeal with the insurance company, and if that's denied, you need to go to court. So Leah, could you share with our viewers how a claim makes its way to the phase where it needs to go to court?
So as you mentioned, there are the three stages. Typically, it's after that second stage, the appeal, when a claim is going to court. And so if the insurance company has denied your initial claim, denied your appeal, typically you're looking at going to court. It can vary a little bit, though, depending on what type of policy you have. So if you have a individual policy that you purchase privately from the insurance company, you may be allowed to go to court as soon as your initial claim is denied. You may not have to go through that appeal process. In those cases, that's typically going to be governed by state insurance law and be litigated in state court, because those policies typically are not governed by the federal law known as ERISA. If your policy was obtained through your employer as a benefit of employment, it's what we refer to as a group policy. And typically under those policies, you must exhaust the administrative appeals with the insurance company before you can file suit in court to fight for your long-term disability benefits. In those instances, it's going to be governed by that federal law known as ERISA that we just discussed. So it's likely going to be litigated in federal court and subject to federal law. So
key takeaway there, you read your policy to understand what it says about your rights to go to court and know your state law.
Right.
Which is a good reason to get an experienced long-term disability attorney involved if you're having trouble with your claim. And so on the topic of ERISA, as you mentioned, some of these claims are governed by state contract law. Some are governed by this federal law called ERISA. What are some of the differences there? Why does it matter? So there can be a lot of impacts if federal law, ERISA, governs. So as we mentioned, you'll likely be in federal court. In addition, generally speaking, your policy may provide the deadline for filing the lawsuit against the insurance company or the other plan administrator, claim administrator. So it's really important to read your policies, plan documents carefully to make sure you're meeting those filing deadlines. In addition, oftentimes under ERISA, you're limited to the record that was built during the administrative process with the insurance company. So during the initial claim and during the appeal, oftentimes you can't get new evidence in court at that point. Similarly, unlike what people often think of when they think of going to court, there's typically not going to be a jury deciding your claim, deciding whether you're entitled to benefits. It's typically going to be a judge in reviewing that administrative record we just referenced. In addition, the judge may not be just deciding, are you entitled to benefits or not? They may actually give deference to the insurance company's decision to deny benefits, which sometimes can be a harder standard to meet. Finally, one big thing is that you typically are fighting just for your benefits oftentimes. You typically can't get punitive damages or bad faith in these ERISA-governed claims. If it's a state law claim, potentially though, right?
Right.
And so what are the different types of outcomes that someone could expect after they put a long-term disability claim in court?
So generally there's going to be three possible outcomes, broadly speaking. It's possible that your claim could settle, and what that means is the insurance company will pay you some set, typically amount of money for you to release your claims, and you don't end up litigating fully. Alternatively, you may litigate until the judge makes a decision on the merits, either granting you benefits or denying your benefits in whole or in part. Finally, in some circumstances, the court may actually remand your claim back to the insurance company. So it's kind of almost like doing the administrative process again a little bit, rather than the court itself making a decision about your entitlement to benefits.
And there are costs associated with everything, right? And so what are some of the costs associated with litigating a long-term disability claim in court?
So the big ones that you're going to see almost every time you litigate are there's a filing fee associated with filing the complaint in court. You have to serve the complaint on the defendants, the parties you're suing, and that typically comes with a fee. In addition, if you're in a case where you end up conducting discovery regarding your long-term disability claim, that does come with expenses as well.
And we represent people all the time on long-term disability claims, and often we're able to do it on a contingency basis, which means you don't pay us anything unless we recover funds for you. And often we're even able to advance some of these costs, and they'll come out of your share of any resolution of the case. But that's a service we can often offer to people. So if you're having challenges or you have questions about your long-term disability claim, please reach out to us. It costs nothing to speak with us to see if we can assist you. Our number is 401-331-6300. You can also find us online at cck-law.com. Please like this video and subscribe to our channel. And if you have any ideas about content you'd like to see in the future, please leave a comment. Thank you very much.